afternoon, everyone, and welcome to Thompson Hine's Investment Management Coffee Chat webinar series. My name is Andy Duvalla, and I am a partner in the Investment Management Practice Group in our Cleveland office. I'm delighted to have you join us for today's session, part of our ongoing Securities Coffee Chat series designed to provide concise, practical discussions on the latest hot topics and trends impacting the financial services industry. Today's session is titled Registered Investment Advisor Dealmaking, Strategy, Risk, and Readiness. RIA M&A activity remains robust, driven by advisor demographics, recurring revenue models, and operational scale. This session will unpack valuation, deal structures, and regulatory compliance and legal considerations, plus practical steps to protect value and minimize risk on both sides of the table. I'm pleased to introduce our distinguished panel for today's discussion. First, we're joined by Shelby Harvey. Shelby is a senior managing associate with Thompson Hine in our Dayton office, where she focuses on mergers and acquisitions and other corporate issues, and has worked in the past with mergers and acquisitions involving registered investment advisors. We're also joined by Salvatore Faia, President and CEO of Vigilant Compliance. Vigilant provides comprehensive compliance solutions to advisors, registered funds, private funds, and broker-dealers. We encourage you to participate today by submitting your questions in the chat box throughout the program. We'll address as many questions as possible during the session, and we'll follow up with you on any we don't get to. With that, let's go ahead and get started. So, Shelby, we've seen significant growth in RIA M&A over the past few years. What do you think is driving the activity in today's market?
So, Andy, it's as you sort of previewed in your intro there, one of the main reasons is the aging advisor demographic. The average age of an advisor in the U.S. is roughly 55. And so there are many advisors nearing retirement. And so accordingly, that means there is a pipeline of motivated sellers. Also, some industry trends are behind this as well. Smaller shops are consolidating to sort of ease the regulatory and compliance burden to help with tech and back office resources. And then sort of the primary driver that I see is that PE buyers have come into this space recently because they're looking for stable cash-rich businesses, which this is. So the PE buyers, coming into the space aggressively recently has been a huge driver for what's resulting in all this activity.
Great. Salvatore, what are you seeing with some of your compliance clients, whether it be on the buying or selling side, and their considerations during this process?
So yeah, and echoes Shelby's points. A lot of advisors are looking for exit strategies, and a lot of these organizations aren't huge, so they've built successful companies. There may be one or two of the partners that are over 55, as Shelby mentioned, and they are interested in exiting. And on the reverse side, we're seeing parties looking to invest in advisors. We have seen more acquire portions of advisors rather than whole advisors, but we just saw a few deals with our clients that from the compliance side, they're asking us to look at, and they're saying, hey, we're seeing, we want to buy the entire entity. So sometimes it's philosophical that people want to, buy and take the entire entity. Sometimes, there's younger persons in the practice and they want to stay in. And there's some older ones that want to, an exit strategy. And they'll often, I know you're going to get to this, Andy, later, but they'll often, participate in the business for a time and stay in the business, which we generally see as a good thing.
Great, thanks. Shelby, what are some of the factors that seem to most influence valuation and deal structure from your perspective?
So the economic metrics are by far the most significant. So having significant assets under management is the highest. Typical range for purchase price is roughly 1.5% to 3% of AUM. But most deals are valued more conventionally, like a traditional M&A deal based on EBITDA. Multiples between 6 and 12 are what I typically have seen. And high recurring fee-based revenue as opposed to a commission-based structure is definitely going to drive a higher valuation from a buyer. And then sort of other less quantitative metrics are influential as well. A younger, diverse client base, especially in like a niche industry, like for example, an aggregation of clients in a specific profession, like professional sports players or something like that might be attractive to a buyer. Growth potential, RIAs that are seen as M&A ready are going to drive a higher valuation, those that are organized, those that have a team and succession plan, because one of the primary concerns is retention of clients. And so if there's a team and a succession plan, that's going to be very attractive to a buyer. And then operations and technology, if those platforms are in place, that can be helpful as well.
Andy, can I make one comment on what Shelby just said? So in terms of the younger, just echo in terms of the age of the client base of the advisor itself, that ends up being extremely important, because the shocking number, if the patriarch or matriarch dies, a shocking number of the clients who would be the sons or daughters go to another advisor. It's something like 75%. So if you're buying an advisor, Shelby noted, you're definitely going to want to consider the age of the clients. So actually, the younger the base is obviously better, because you have a longer lead time there. So that's as we see, an important consideration.
I totally agree. So ultimately what buyers are looking for is a cash machine, right? And so if you've got a younger clientele, that cash machine is going to keep generating for a longer period of time. So it just sort of follows logically that would be something a buyer would consider.
Salvatore, and I think the next point was going to be, what, and Shelby too, what role does, a regulatory history and compliance culture, play into, the structure and potentially the deal terms?
Yeah, that's a great point. Thank you, Andy. What we're seeing is that we have a bank that we work with. They tend to acquire a lot of advisors, so they'll come in, they'll have their deal counsel, so have someone like Andy and Shelby on for the deal, but we'll come in and do a compliance review. So what are we looking for particularly? We're looking for, obviously, we're going to look at the last SEC exams, any state exams, any pending exams. We're also going to look at the state of the compliance program. Is it solid, or is it a mess? But we're also going to look and ask questions of the principals there, because sometimes you'll see things that are not a problem with the advisor is owned separately, such as they own the building that they're in and they're renting the building from the entity. So that may be fine, everybody's in-house, but if there's an external buyer, that may influence, or certainly something that Andy and Shelby are going to want to talk about, how we're going to handle the building. Is there going to be a lease back, et cetera? And then another thing is conflicts. So we've had advisors that have had other referral relationships with other advisors. Again, when everybody was all in-house in this group, didn't create a problem, but could create a problem, or or something that Andy and Shelby want to say, hey, what's the deal going to be going forward? You had this referral relationship. It's now changing because the ownership's changing. How's that going to change? One other thing we've also done is we've encouraged clients, and Visual has some CPAs on staff, so we do this. It's kind of like to look at the returns of the advisor and stratify the returns, because if the company's performing well, and we use some metric for over 3%, over 5%, over 8%. How high are the returns for the clients? Because if the company's performing well, that's a good thing post-close. But closing and sales often trigger clients to reconsider the relationship with that advisor. So to the extent that the advisor's investments have been performing well, it's certainly, as Shelby said, the parties are looking for an ongoing cash flow. It certainly makes it more probable that they'll stay with that advisor.
Great. Thanks, Salvatore. And maybe a question to you, Shelby. So if you were like say if Salvatore's firm was doing that type of due diligence compliance check and maybe didn't find the cleanest history, how would you discuss that point with your client, and maybe how would that potentially affect that risk? How would you think that would affect maybe it's a pricing or maybe it's other terms of the deal? How would that come into play from your perspective?
Yeah, so my reaction to that would depend on whether or not I was representing the buyer or the seller. But there are a number of ways we could get at that. Like you said, maybe there's a reduction in the overall valuation to sort of accommodate for that compliance risk. But there are other things that you could do. The structure of the deal is relevant there. So kind of backing all the way up to the fundamentals of M&A, which I'm sure many of you on this call are already familiar with, but a deal can be structured as an acquisition of equity or an acquisition of assets. And I would describe an acquisition of equity like buying a house with all the stuff in it, including all the skeletons in the basement. And an asset deal being all the stuff inside the house comes out of the house and you take it away. And so you can leave those things in the basement that you don't want. So, I would offer a client structuring considerations around that. An asset deal in a situation where there was a lot of legacy regulatory problem, I would recommend an asset deal from the buyer's perspective, because that would allow the buyer to cherry pick the assets and liabilities, and it's not foolproof because there could be successor liability or other risks associated with it. But overall, an asset deal is going to provide a buyer with more protection from historic liabilities like compliance risk. An equity deal, though, like I said, that you're going to buy the company with all of its skeletons in the basement. And so if there's a regulatory risk and we have to do an equity deal for some other reason, we could also suggest line item indemnities or certain indemnification package offerings to protect the buyer from the risk associated with seller's compliance history.
Sure. And maybe I had another question, but I'll save it to our deal structure section. Salvatore, when you're in the process on either side of the transaction, could you talk a little bit about the critical regulatory filings and disclosures that RIAs should be thinking about as they go through this process?
Sure. So thank you, Andy. So as Shelby noted, I mean, you're definitely going to want to, if check the regulatory background on the entity and on the persons in the entity. So, sometimes they'll have a dual license. They may be FINRA licensed. So you're going to want to check that as well. And so after the fact, you should, probably Shelby and Andy would create a checklist for you and say, look, what do we have to update? For example, let's start with the ADV. We're going to have to update the number of employees. We're going to have to update the assets under management. Hopefully that's going up, obviously. And then we're going to have to update any business lines that we had and did not have. Okay. 4, we should also look at the states in which the prior company was operating in and the new company's operating in. Maybe that's totally the same, but maybe now you have clients that are, have over 5 clients, for example, in a particular state. You're going to have to, notice register in that particular state. Also review any other filings, state filings that are required. So that's certainly should be on your list. And then, I don't know if we want to get to here, but certainly want to review the compliance policies and procedures. But I think we're going to talk a little bit about that in a few minutes. So the ADV part 1, ADV part 2. Andy, I know you always like to reference, there may be different fees charged for new clients by the new firm. The other firm may have had, smaller clients, and now it's acquiring a firm with larger clients. So there may be additional discounts and fees. There may be additional conflicts that we wanted to disclose. And so basically looking at the Form ADV Part 1, Part 2, CRS, et cetera, and saying, hey, what changes do we need to make here? And, your deal counsel can take you through all those pieces.
Sure. And I certainly agree. So, yeah, like I said before, and you just alluded to, but the fees, obviously, it's highly unlikely that 2 different entities exactly have the same fee structure. So thinking about how to address that in your ADV. And also, as Salvatore said, it can, this relationship, especially, maybe if you're just buying a part of another advisor and becoming an affiliate, conflicts of interest. And I don't know Salvatore's perspective, but my thought on the ADV conflicts of interest section is that you can't over disclose in that section. So I feel very strongly that if there's any type of relationship where even the optics of it, even if the practicality of it doesn't disadvantage clients or shareholders in any way, I feel it's very important to put that all out there, because you just don't want to be second guessed later on. And if there is some relationship between entities that wasn't disclosed that could in order to either's benefit, I just feel it's obviously best to put that out there in the light of day. So I didn't know if you had any follow up there, Salvatore.
Yeah, I think they're all great points, Andy. And I will say, you do see that, for example, if you see an advisor, they may also have a hedge fund that they advise. And now, that's something new for the purchasing firm. So you certainly want to disclose that. And, Andy and Shelby would probably take you through sort of a list of considerations. Do we give the clients a discount because now we're charging them a fee, and they're going to be, a hedge fund client fee. So, Andy and the team would take you through that, but I think they're great points, Andy.
Yeah. Okay. So we've kind of touched on it a little bit, but why don't we go into a little bit more detail, Shelby, on, transactions, the actual transaction structure. So, I think you've given at a high level the key differences between an equity and asset purchase, but maybe discussing those details a little bit more. But then also, there's obviously other considerations as that process goes through the negotiation phase regarding tax or other liabilities. So what are your thoughts there?
Yeah, so I already spoke to this a little bit in terms of how you would manage risk in one of these deals. So from like a liability perspective, structure is relevant, but there are other reasons for why you choose one structure over another. An equity deal in this context likely makes the most sense because it minimizes sort of the administrative efforts associated with closing and integrating. Because like I said before, if you buy the equity of a company, you're buying the whole house, and everything stays inside of it, including the client contracts, including all the regulatory registrations. All of those things will stay inside and don't need to be assigned, which minimizes effort required in a deal, but also can help with the client attrition element that we were talking about before. As I said before, an asset deal can minimize exposure because it allows a buyer to cherry pick assets and liabilities that it wants, but it can become a pretty heavy administrative hassle because every contract will need assigned, and there will be likely a higher regulatory burden associated with that deal. The tax reasons for this I find to be less significant for a business of this type because it's not heavy with hard assets, but typically a seller will prefer an equity deal for tax efficiencies, and a buyer will prefer an asset deal because they get a stepped up basis, but that's less relevant here because there are not tangible assets involved in most senses.
And Salvatore, what have you seen with your clients as to preference for what they've been doing, or whether it's fully acquiring or maybe just acquiring a percentage of the equity?
We're usually, we just see a little bit more equity deals and as opposed to the asset deals. For the asset deals, as Shelby said, it can be better, but you sort of get layers of protection in these things, which Shelby and you would take the client through. If you do an asset deal, could they still claim well? It's a continuation of the enterprise if something goes wrong. Yes. I was wondering from Andy, from you and Shelby's point of view, are you seeing clients make, particularly when they're purchasing, do you see them have agreements in terms of the client retention metrics? In other words, are they generally saying, oh, we'll buy the company for this much, or are they generally trying to say, oh, we'll buy the company for this much, and if there's a lot of clients leave, we'll pay less? So I know what we see. I just was curious as to, we generally see them, buying it outright, but, you just wonder, if people think about client retention. I was wondering what you guys are saying.
Yeah, so I typically see that handled through an upfront purchase price with an earnout on the back end that's based on the retention of a certain percentage of clients or revenue over time. And that earnout could go for 2, 3, 5 years, depending on what the buyer prefers. But that's typically how I see the buyers protect themselves from client attrition. They pay an upfront purchase price and then come back with an earnout post-closing.
Right. Yeah, that's good. Yeah, certainly if you all can negotiate for that's a good thing, you know.
And then Shelby, so I guess my takeaway here, but correct me if I'm wrong, say all things being equal, that your suggestion to a would be to structure as an equity deal. Is that different for buyer or seller in your mind?
In my mind, I think it's beneficial for both sides, unless there's really significant liability issues that a buyer is concerned about that we can't somehow get around through indemnification or, setting the purchase price at the right level. But yeah, I think because of the fact that an asset deal is going to require contract assignments and increase regulatory issues from both the seller and buyer perspective, although not perfect, an equity deal seems to be most favored in this space.
Okay. And I would say from, one of the things that comes up often in my practice, especially, excuse me, in an equity deal is when any change of control considerations.
Right.
So if you are selling, just as a reminder, the kind of threshold is usually 25% under the SEC's eyes as to what a change of control is. And that has an effect, certainly if you're a registered fund advisor, that will terminate your advisory agreement. So you'll have to go out to those affected fund shareholders and get their approval for a new advisory agreement. If you're simply doing SMAs, institutional accounts, certainly review the terms of your agreements to see what type of client consent may be needed throughout that process. And there's a lot of facts and circumstances that go behind what may constitute a change in control and thus the termination of your advisory agreements. So maybe someone you are selling 25%, but maybe it's just equity and not a voting position. So, voting is what carries the day when it comes to change of control. So deals can be structured with that in mind to avoid change of control potentially, or based on the other kind of ownership details of a company. So something to think about as you are selling a piece of your business. We did get a question, Shelby, which I think would be best directed to you. Why are asset deals associated with higher regulatory burden? And can you explain that from both the buyer and seller's perspective?
Yeah, and I'd appreciate Salvatore's help too, from the regulatory side. But an asset deal will require assignment of everything versus a change of control, and so the requirements are more strict for an asset side deal. Sal, do you have thoughts on that from the regulatory side specifically?
I would agree. You're probably going to need to get the investment advisory agreement, get a wet signature on the investment advisory agreement documents if you just do an asset sale. So Shelby said it's a little bit easier if you do an equity deal. So, if you have 250 clients, you might have to get 250 signatures on new advisory agreements, which is a bit of work, quite frankly, if you're trying to complete a transaction and get all the assets to transfer.
And just to clarify with the point that Andy was making about a change of control, an equity deal doesn't completely insulate the transaction from regulatory concerns, even though everything does stay inside the house. The change of control is triggered by 25%. So there's still, it's not a nothing.
Yeah, so I would just emphasize that, Shelby, that point that Andy made as well. So if you have an advisor who has, managing an ETF or a mutual fund, you then that 25% triggers the requirement to get a new 15C agreement in place and have the board approve it as well, as shareholders. So that's, something in either case that really has to be considered. It's not, it's done a lot. So, because it happens, but you do have a bit more work and sometimes expense there.
Okay. Another question. Do you see clients try to creatively manage around the proxy issues the deal raises? And how do you see proxy issues impacting deal terms and price? So I can take that. And if Shelby or Salvatore has any follow-up, definitely welcome. Like I said, sometimes, it might just be a purely economic interest maybe sold rather than one that carries voting rights, or, selling below 25% to avoid that. Otherwise, if depending on how the rest of the concentration of ownership is sold, say if somebody's selling 25%, and there's a super majority, or something's based on the voting rights or what's needed from an organizational document standpoint, to bylaws, corporate documents, maybe the same person who has always been the owner but sold just 25%, their vote would still carry the day. So obviously there's a whole host of SEC no action letters on this topic, but as some of you may know, the SEC stopped issuing no action letters in this area just because of it's such a facts and circumstances determination. In terms of how proxy issues impact deal terms and price, obviously that's a consideration between the two parties as to how those will be allocated. From my experience, usually it's the acquiring advisor that pays those legal filing fees, any proxy solicitation fees and expenses. And so it's obviously a good thing to work early on with proxy solicitor. Well, before even that, have a good understanding of your shareholder demographics. Is it a tightly owned fund, or is it a bunch of, retail clients scattered all over the place? Is it owned through advisors that you know well? And then having a sense of whether you need a proxy solicitor, and then a proxy solicitor can obviously give you a sense from their experience as to potential costs of solicitation, what level of solicitation will be needed to obtain a favorable vote. So like I said, that's usually borne by the acquiring fund advisor, but sometimes it's allocated between the two as just part of the overall transaction. So I don't know if Salvatore or Shelby has any thoughts on that particular question.
Yeah, I was just going to call out one point that you said. I thought was a good one. So, in terms of, who holds the shares, sometimes the advisor knows the clients in their fund. They have an advisor, long-term advisor, and the person's, they're managing money for the parents, and the children want to come in, and they put the children in a mutual fund or an ETF that's managed in a similar way. So sometimes they know the clients, and it's easy to get the proxy votes. As Andy said, sometimes it's more diverse and it's harder to get the proxy votes. But additional thing to consider, if you're buying, the whole advisor, that could work against you because, sometimes they're very, they're in that fund because they know and have known that financial advisor for a long time. And if the advisor leaves, we've seen cases where, the assets will often, go out pretty quickly. So again, the points that Andy and Shelby mentioned on retention and payouts and earnouts is a good point to consider as part of the overall analysis that you're doing with your law firm.
And then I was also going to mention that, mutual fund shareholders generally do not get a lot of proxies. They don't have annual meetings. There's not other annual approvals that they see. So when they don't necessarily understand what they're getting when they're getting a mutual fund proxy to approve a new advisory agreement. So oftentimes the case is that the percentage of votes will be very high in favor of approving a new agreement, but you still have to reach quorum for the meeting. So it's usually the quorum issue that is the harder one to overcome in the context of getting shareholder approval for a new advisory agreement. So you'll even say at the end of proxy campaigns, solicitors finding shareholders and just say, we don't even care if you vote against it. We just need you to vote either way, just so we get the quorum. So yeah, again, just having an understanding of your shareholder demographics is very important in case you have to go down that road. Maybe pivot, Shelby, a little bit to kind of risk and diligence. Obviously, with any M&A transaction, you're going to be putting together a due diligence checklist. So from your kind of deal making perspective on this, what were some of the things that you would have on that checklist as opposed to what Salvatore would be looking for?
Yeah, so from the buy side of the deal, we'd suggest a diligence request list that's tailored and scoped to the target business. But the key areas of concern are compliance, as we've discussed at length, the client contracts and, population and personnel. So the diligence request list would include heavy list of questions for each of those categories, and with ultimately the final questions in mind to assess whether there's post-closing risk to buyer because of regulatory noncompliance. What do we need to do as far as transitioning these client relationships from a contractual perspective? Are there any unusual terms? What's the fee structure? How do we integrate that going forward? And then what's the bench strength of the personnel involved, and how sticky are those personnel to the RIA? Because as we talked about before, the maintenance of the personnel is going to result in more client retention. So those three considerations are key. There are others, of course, more operational things like provide a copy of your lease agreement or, things like that. But those three areas are going to be of real significance in this industry and deals in this industry.
And Shelby, are you seeing, when they are about to do a deal and you're taking the clients through those considerations, lots of times, I suppose there's no employment agreement, but are you recommending that your client, say, gets employment agreements in place with key personnel, or are you just saying, hey, sellers telling you we think the key people are going to stay?
Yeah, that's a good point. So non-competes are a significant consideration here, and so the non-competes will come for the actual shareholders of the seller. That will be like a sale of business deal related non-compete that can go on for 5 years or so. But then non-competes as to employment agreements are a little different, and in some jurisdictions not enforceable. And some are, though, but I see those going for a little shorter period, maybe 2 years, non-compete after you leave working for the RIA. And those are significant things to consider when trying to retain a group of personnel. And then the employment agreements also, if they provide for good incentives, good comp, all of those things are important to make sure you keep your personnel happy and on board. That said, there are certainly facts and circumstances around a deal and deal personalities that may mean we don't do it that way. But I sort of, at a high level, would typically recommend that we have employment agreements in place with the people we really, really care about, and that we've got an enforceable non-compete against them, and that we've provided them with a really solid comp and incentive package so that we can keep them around and keep our clients.
Right. And then so Shelby, so for people who are shareholders, obviously you have that non-compete, but then, there may be a group of second tier people who are important to the enterprise who don't have, because they've been working for the enterprise, don't necessarily have an employment agreement with the enterprise, that you may be recommending to the client, hey, why don't we put an employment agreement in place that says this employee, it's bilateral, we're going to pay you for 3 years employee, but and so you got an employment agreement, but you're going to agree to stay. So you're recommending those in some circumstances.
Yeah, that would be the way I'd go. And if a client for some reason felt like that was a no-go just based on the personalities of the folks involved, I would at the very least make sure that the comp packages for those people we really care about were thoughtfully considered in making sure they're retained.
Good, yeah.
Um,
So,
Go ahead.
so you didn't want to have necessarily a point agreement with some, they might bump up the comp to encourage them to stay, I'll say. So you might recommend that.
Salvatore, what would be some of the compliance checklist things that you would look at? I think, you've touched on them in pieces so far, but what would be the usually laundry list of items that you would be looking for if you were conducting due diligence from your compliance perspective for a client?
Yeah, so, in terms of what we discussed already, I'd be looking for the conflicts of interest. You have the change of control, so, go through the relationships with the parties and, interview them. In one case, we found, an advisor had a related business. They did, tax work for clients. They did budgeting for clients and things like that. But they also helped them in this separate business with selection and overview and selection and oversight of other investment advisors, which potentially we saw as, well, really that should be registered activity. So Shelby and you talked a little bit earlier about post-closing risk. So that presented a little bit of post-closing risk. Now, what they did with what counsel did in that case, and what you guys would probably do for them, is it say, hey, look, let's restructure this now so that this activity, which was non-advisor activity, either ceases or becomes part of the advisor. So we're looking at that. We're looking at we talked about, doing searches on the employees and seeing what turns up not only on Google but FINRA and other searching places, and outside business activities. We certainly want to look at that because sometimes these employees have additional activities. Like we've had people that also worked at the advisor, maybe not the top level persons, but they're co-manager of a hedge fund that the smaller advisor really, was okay with, but maybe the larger advisor coming in is not okay with because they feel like that's taken away from their business time. So I would say, background, outside business activity, conflicts activity is kind of, high on the compliance side, to take a look at, before the purchase.
Sure. We have another question I'll interject with here. So it's my understanding the assignment clause of the seller's investment management agreement dictates the positive or negative consent required from seller's client base. And that is true. And I've seen it done both ways. Obviously, I think the stronger, but obviously more burdensome process is getting positive consent from each of the affected investment advisory clients. That obviously can't be second guessed. If you have a piece of paper from someone saying I consent to this change in control and here's my new IMA with the surviving entity. That said, I have seen negative consent used in situations that have held up, and there haven't been any issues. Shelby, I don't know if you have any thoughts either way on that.
Yeah, so the negative consents, it's my understanding that is becoming less and less favored, and that's sort of maybe a riskier way to go about it. And so getting affirmative consent is the better way to approach it. But the negative consents can be used. Obviously, that's easier, but I see that that's becoming less favored in the market and by the SEC too.
Any thoughts there?
I would just add to that is, look, Shelby and Andy would take the parties through it. These are kind of, case by case bases, not only in the facts and the documents, but also, some advisors feel like, listen, I was at college or college roommates with my friend and I do other children. I'm not going to have any problem getting a positive consent. I'm going to stop over there. I have dinner with the person, every Friday night anyway. So, it's kind of fact specific. So if you can get the positive, it's good, but it is a lot of work. And sometimes, trying to get the positive consent could could have people take a chance to reconsider the relationship. Well, gee, my son-in-law is now a financial advisor, and my daughter's been bugging me to use him, and so it is something you want to go through with your counsel and think about strategically. So
Yeah.
So
sort of a balancing act, and are we worried more about risk? Are we worried more about attrition? And how do we balance those considerations?
Exactly. You want to have the assets when you're done here, so it's it's certainly balancing, I would say. Yes.
Yeah, and I've actually seen a bifurcated process where the initial thought was to get positive consent from everyone, and you got 95% of everybody coming back with a positive consent, but and then using negative consent for the other 5. So again, that's a weighing of the risks in that situation. Second part of that question: does the deal structuring, whether asset or equity, also play in the role of consent process that's required from the clients? And my perspective is I don't think it does, but I'll let Shelby disagree with me if she has a different thought there. Usually there's probably going to be, I would assume, some representation or covenant in the agreement that a certain level has been achieved or that it's been fully received as a condition to closing.
That's right. That's what I see too, Andy. But just to kind of continue on with the balancing elements of it, there are so many considerations that could make something go from one way or the other. And I don't see the consent process being sort of the number one factor that would inform the structuring decisions. But it's a relevant factor, but sort of lower on the list of things from what I see.
Great, thanks. Salvatore, so maybe like post closing or as we're moving up to close, what are some of your thoughts and suggestions on integrating maybe 2 different compliance programs and regimes in order to kind of make that as smooth as possible as they move forward in the overall larger entity?
Sure. So generally speaking, the larger entity will want to keep its compliance manual and code of ethics, and everybody's used to the forms, et cetera, and a new entity will have to change. But if the new entity is doing additional business, and you're going to have the existing larger acquiring entity, maybe you're going to certainly add some additional compliance policies and procedures around those businesses, and so you may lift out things. It's always good. We like to have a training session relatively quickly thereafter, and to get the new folks understanding what they have to pre-clear or what they have to do by code of ethics, et cetera. So we want to make sure we get clear understanding there. And then just Vigilance overall philosophy is to simplify the compliance manual and code so that so that it's easy for everybody to comply. For example, if one firm says you have to pre-clear everything, and the other firm says you only have to pre-clear what the SEC says you have to pre-clear, which is essentially IPOs, initial public offerings, and ETFs or mutual funds that are run by the client. You might want to consider simplifying that if it makes sense and it's consistent with the organization. Some clients are very strict. They say, I want to pre-clear everything, and others are, have a view that, look, they're going to trade in and out of Microsoft or Ford or Apple. Probably no one's going to affect the price of that entity, so a little bit more flexible. So I would say look at those 2 manuals and policies. It's a good chance to update those policies at the merger, maybe simplify some things. Vigilant just finished a client, a client had acquired a number of entities and had like 3 or 4 or 5 different compliance manuals, and hey, let's put these together and simplify it. So it's a good time to do that and simplify the manual, make the manuals consistent, maybe update them a little bit.
Okay. And obviously, with more people going back to the office, would you suggest to an advisor that's acquiring, say, offices in new geographic areas, would you suggest, either Vigilant is in your role as maybe outsourced CCO, or maybe just advising the advisor to actually be doing in-person compliance visits just to get a sense of those offices and dynamics there, to make sure that those people feel part of the larger new organization and know what the policies and procedures that they now have to adhere to.
Right, and that's a great idea. So we, do that initial training and then spend some follow-up time there, maybe follow-up time, if the other entity has a separate trading group, how are you guys trading? Who are you using? How much is it costing? And what's the new firm doing by way of trading? You're getting best execution. Also discussing, outside business activities, code of ethics, but also things like, making sure they know, hey, what's the process? If there's a new client now, counsel, Shelby or Andy are going to have drafted, they're going to have maybe have a new client agreement that they want to use going forward for new clients. We talked about the existing clients already. So there's certain things that the counsel's going to want to identify that we'll get a chance to emphasize, when we're doing those reviews. And it's good to, get in front of the people and they can let them ask questions. Say, hey, we always did it this way. If I needed to get a pre-approval on a transaction, I always walked next door to Peter or Susan, and they told me whether I could do it. Now I have to go online. Can you explain what I have to do? So good chance to spend some time, FaceTime, Andy, especially as you mentioned with the new offices.
Yep. I think another area I see that's sometimes, I wouldn't say difficult to reconcile, but one that needs to be reconciled is approaches to record keeping, how it's done. Sometimes it's like, oh, we just got the signed agreement and we put the signed page somewhere in a file somewhere, and someone else may have a very robust online record retention system, and simply throwing a wet signature somewhere in a file somewhere that can't be readily available, which is something the SEC would expect at an examination, that you can provide your records. Certain records should be readily available, and they certainly will ding you through the examination process if you can't provide them in a timely manner. So that's another area, I think, Salvatore, that's important to think about.
Good point, Andy.
Okay. Maybe some practical advice, kind of next steps, Shelby, from both the buyer and seller perspective. If you were if you're an RIA now, maybe you happen to be in that demographic where you're 55 or older, and maybe looking to exit the business. There isn't a logical successor, or you're looking for a liquidity event, whatever the case may be. What are some of the things, if you're looking to do something in the next 2, 3, 4 years, what are some of the things you should probably be thinking about and doing now?
So sort of two things. Consider the valuation drivers as you continue to grow and scale your business. If you can get not all of those things right, but a number of them right, it's going to result in a good payday for you. Recurring fee-based revenue, strong EBITDA margins. That's all great stuff. Young clientele, niche area, those types of things are good to focus on in terms of making sure you maximize your payday when it's all said and done. And then also, Andy, kind of going along with your record keeping point, you mentioned it in the context of the SEC, but it's sort of interesting and important too for a buyer that an RIA is organized and has its contracts in a folder and is sort of easily able to react to the diligence request of a buyer. Is going to inspire confidence in the buyer and make the process easier for everybody involved. If you're not, hauling up papers from the basement and scanning them for 15 days, it's easy if you've just got a zip file with all your clients, or they're, loaded somewhere, you can easily share a sampling of them with a buyer. Sort of keeping your records organized and be able to present the case of your business and its value to a buyer when they come knock on the door is going to put you in the best position possible. And from the buyer side of things, personnel transition, we've talked about that heavily. Client transition, since personnel transition equals client transition in a lot of respects. So personalizing client transition messages to minimize attrition, make people feel valuable after closing and make them, stick around. Make sure, like Sal had talking about, compliance efforts, you've got those in place to get everything streamlined and integrated well after closing, and then, have a transition plan for billing, accounting, all of those sort of back office functions are things a buyer will want to consider, in the background as they're pursuing a deal and moving forward with it.
Yeah, that's all great.
Go ahead, Salvatore.
All great points. Thank you, Andy. All great points, Shelby. We like to think we tell clients GAR, growth in assets, growth in clients, and retention. So the GAR piece. One of the things that, in terms of new clients, if you have an existing advisor, they may have $100,000 minimum for a client or $250,000 minimum. So if you're in that, as Shelby said, if you're in that year, 3 or 4 years you're thinking about selling, you may reduce that minimum, or you may say, you know what, generally I don't take other accounts of a minimum size, but they're a relative of a long-standing client, I'm going to take that client. And so you build up that client base, even though it's a bit more work for the advisor to have more clients. Another thing is, for consideration is the financial statements. We from compliance point of view, we look at this too, but it also plays into what Andy and you stated and Shelby is that, like, eliminating loans due from partners, eliminating other, related party transactions. Right. The financial statements that look cleaner. If you have to get a valuation of a building, you get a valuation of a building in advance, and then you have maybe 2 or 3 years of valuation. Another thing you can consider is, do you as the advisor, while you're still in control, want to have audited financial statements? Most advisors that we look at, and I'd be interested in what you, Andy, and Shelby see, is most advisors do not have audited financial statements, unless they're the largest, So, but there are things you could consider an audited financial statements if you think that's really going to help the buyer. But lots of things can be done to clean up the financial statements because most are on a cash basis. So it's not like it's complicated accounting, but there's certain things you could do, as I said, to clean up those financial statements so that when, if Shelby's representing a buyer and they come in, hey, it looks pretty straightforward, and you got 2-3 years of financial statements. And even if you don't get them audited, you may get, a CPA to, issue a compilation report or some other report on.
Yeah, I agree, Andy. Sal, that's a great point. And you're right. I typically see the compiled financial statements instead of audited for clients in the RIA space.
Okay. Don't think we have any questions, so I'll give it another minute. But anything from a buyer's perspective, how you would prep for integration other than what you've already touched on, Shelby? I was going to ask maybe what you thought about, like, maybe key person and key person insurance policies for advisors acquiring a business where there is 1 or 2 key people that can be obviously very important to the retention of assets that you're trying to acquire.
Yeah, I see that as a useful tool in the space, but it's not perfect because, if someone were to pass away, you get the payout, but if you lose all the clients, it helps some, but still your cash machine is damaged still. So it's a risk to be considered, and that's one way to plug the hole, but it's not perfect.
Yep, no, agreed. Hopefully it's, you don't avail yourself of it, but it's
right
to mitigate that potential issue.
We
do have another question. Is it your experience that the SEC exam focus may shift for RIAs that are in the business of acquiring other RIAs? And my initial thought here is to what I just asked Salvatore a little bit ago. I think they would be very interested in how well you are integrating those people into your program. If you are getting those new offices, have you done the trainings, the visits, making sure that they understand your compliance culture? You don't want the SEC to go to those kind of satellite offices and see, the old compliance manual from the previous advisor just sitting on the shelf and nothing else has really been done. So I think I'll let Salvatore jump in, but I think it would be mostly integration and compliance of the compliance policies and procedures.
Yeah, I would agree with that, Andy. I would agree with all those points. And just do a good training afterward. That's good optics if the SEC comes in. Make sure the entity you're acquiring has an annual review report pursuant to Rule 20647. So when when Shelby prepares that list, that due diligence list, that's going to be one of the things on the list. And is it, look at it, is it like 2 pages, or is it something that's 20 pages and looks like they took compliance seriously? So we're in a better risk perspective. But if it's a thin report, as soon as you take them over, come in and do a review. So I'd say, yeah, Andy, I definitely agree with that. One point I just want to emphasize, and Shelby hit it, but I just want to emphasize a little bit, is that technology and operations. It's a good chance if you're thinking about selling your advisor in 2 or 3 years, maybe, look at, the operations and the systems that you're using. And if there's something that Susan usually copies all these things and, we're in kind of messy files, let clean that up and make sure you have enough, op support. Maybe, if you're the advisor and the person is getting a little, Susan's now 60, get an additional person in there so that the buyer, can feel confident that they have ops persons in there. And it's generally not that expensive. So I would just say, maybe a time, that 2 or 3 year period, just to, clean up some things and make sure, if you weren't going to sell, you might not update some system, but you updated, and usually the technology spends have come way down. So I would say that's something to consider as well.
Yeah. And getting back to the last question, another area that I've seen scrutinized, and I mentioned this before in the ADV disclosures, is the discrepancy in fee structure. So, understanding, the SEC, I've seen where they've scrutinized what they consider to be clients that are similarly situated, but because of kind of historical different services that were provided to one group versus, the group on the other side, the SEC had a hard time understanding why they were different fees for what they consider to be the same types of clients. So just being clear and concise when dealing with the fee section of your ADV disclosures.
Yeah, great point. Definitely.
All right. Well, we are almost at the top of the hour, so I would like to thank, first of all, Salvatore Faia and Shelby Harvey for being our panelists today. I think it was a very informative session, so thank you both. I'd also like to thank all of our attendees on behalf of Thompson Hine. We hope you found the discussion informative and that you'll join us for future sessions in this coffee chat series. I'd also like to let everyone know that we'll be hosting an RIA merger conference, an in-person event at our New York office on November 10th. You are all invited to attend, and we will be sending a formal invitation to that event later this week. If you have any additional questions or like any more information about today's discussion or the RIA merger conference, please don't hesitate to reach out to us directly. Thanks again for attending, and enjoy the rest of your day.
Thank you, Andy. Thank you, Shelby.
Everybody.
Thank you.
Bye.
Bye.